Hello, everyone. This is Mark Masters from Secrest Wardle. I'm here with my partner, Renee Townsend, and we're here to talk about what everyone's been waiting for about a year or so now, which is the Supreme Court's decision in the Bazzi case. We wanted to talk a little bit about the history of how we got here, including the history, I guess, of the innocent third-party rule, the easily ascertainable rule, their destruction or abandonment in the last couple of years, as well as the impact of this new Bazzi decision, which just came down on June 18. Renee and I are going to go through a couple of points. Renee's going to touch on the history. I'll touch on some of the history of the Bazzi case itself. I was actually thumbing through my transcript of Mr. Bazzi. I took his deposition back in 2013. Can't believe it's been almost 5 years already to get to this point. To go through some of the facts and a little bit of the procedural background of the Bazzi case itself. But I'll kick it off to Renee first to give us some of the background and history.
Thanks, Mark. As he said, we're just going to be talking about how the innocent third-party rule came to be and kind of how the case law led up to ultimately what came down last week on Bazzi versus Sentinel Insurance Company. The opinion was released July 18th, 2018. It was authored by Justice Curtis Wilder and joined by Chief Justice Markman and Justices Zara, Bernstein, and Clement, with a dissent written by Justice McCormick and joined by Justice Viviano. But before we can talk about Bazzi, we have to kind of lay the groundwork as to what is the innocent third-party rule and how did it come to be in Michigan. It was established in a case called State Farm versus Kuryalowicz in 1976. And basically, in that case, the Michigan Court of Appeals held that the misrepresentation of an insured in procuring an auto insurance policy did not prevent recovery against the insurer by third parties who had been injured in a motor vehicle accident involving the insured. So in that case, a claim was made against State Farm after a serious accident where one person was killed and 5 others were injured. Prior to the accident, the insured had obtained a policy by submitting an application form that asked if he had ever had his license suspended or revoked. He answered no to that question, but in fact, it was suspended for a month the year before. When State Farm learned of that misrepresentation, they took the position that the policy had been procured by fraud, rescinded the policy, and deemed it void ab initio. Michigan Court of Appeals ultimately held that the trial court in that case was correct in rejecting State Farm's argument that the rescission of the policy would bar recovery from third parties who were not involved in that misrepresentation or fraud. The court also relied on what was ultimately coined as the easily ascertainable rule. And in that particular case, if State Farm had run a 25-cent background check, it's 1976, so it cost 25 cents. If they had run that 25-cent background check, they would have learned that the driver's license had been suspended for a month, and the court deemed that that was easily ascertainable in the sense that it didn't take much for them to figure it out, and so they could have done that. They chose not to do so, and that's how the innocent third-party rule and the easily ascertainable rule were ultimately established in Michigan. So how did we get to the next step? Well, Titan Insurance Company versus Titan is the next case. That was kind of a big case in that entire line. This is a 2012 case, so it came much later. It overruled State Farm versus Kuryalowicz and abolished the innocent third-party rule in Michigan. In that case, the court granted leave to appeal to address whether an insurance carrier could avail itself of traditional legal and equitable remedies to avoid liability under an insurance policy on the ground of fraud in the application, where the fraud was easily ascertainable and the claimant was a third party. So it was pretty much the exact same situation that we had in that 1976 State Farm case, but the court reached a different holding. They overruled that State Farm case and all of its progeny and held that there was nothing in the law that warranted the establishment of the so-called easily ascertainable rule. In Titan, the case again involved an insured failing to inform the insurance carrier that their license was suspended. An accident occurred for which they sought a declaratory judgment. The insurance company filed a DEC action seeking a declaratory judgment that would not have to indemnify the insured for claims filed against her by any injured parties. The court held that an insurer can use any traditional legal and equitable remedies available to avoid liability under a policy. That could be cancellation, rescission, reformation, as long as there's fraud in the application for insurance or fraud done by the insured, even if it's deemed to be easily ascertainable and the claimant is a third party. So basically what it comes down to is Titan abrogated the innocent third party rule created by State Farm versus Kurielewicz, and the innocent third party rule ceased to exist in Michigan. So where are we now? And that's where I'll throw it back to Mark to talk about the procedural history in Bazzi, as he was defense counsel in the trial court.
Thanks. So when the Bazzi case came in, certain red flags were raised for me as I reviewed the materials we had at the time about whether or not this commercial policy was fraudulently procured and whether or not the named insured Mimo Investments, this supposed company, was actually a real company. We have been seeing a rash of shell companies, if you will, that are popping up and procuring auto insurance policies for companies that either don't exist, never existed, or sometimes companies that someone just simply went online with the state of Michigan and opened up a LLC and called it something and got an insurance policy. Or sometimes we see maybe it's an actual business, someone has a painting company or something like that, where they just start throwing vehicles on a policy that don't belong there because they're known by the owner's brother, sister, kids, whatever, and suddenly you have a fleet of, I'm not exaggerating, 20 or 30 vehicles on a fleet policy for a company that never did more than, say, $10,000 or $20,000 in business a year. In this case, in the Mimo case, it appeared to us that there were certain red flags that this was a suspicious procurement of an insurance policy, certainly that there was alleged fraud involved. So what we did, we filed a third-party cause of action against the Bazzi sisters, which were Mr. Bazzi's mother and aunt, who were involved in this Mimo Investments and the procurement of the subject commercial policy. And in that third-party complaint, we actually got a default. They never answered, and ultimately a default judgment rescinding the underlying policy and getting a ruling that fraud had been committed on Sentinel. Ultimately, the Bazzi sisters obtained counsel. They asked the court to set aside the default, but ultimately the trial court, after lengthy hearings, determined that there were not grounds to set aside the default judgment, and so it stood. And so we had an uncontested, at that point, determination by the trial court that there had been fraud committed in the procurement of this policy and that rescission of the policy was appropriate, although the trial court seemed to think that, well, this innocent third-party rule still existed. So they allowed the case in chief of Mr. Bazzi to continue onward. Obviously, we were not happy with that conclusion or that ruling from the court. We sought an application for leave to appeal with the Court of Appeals some number of years ago. The Court of Appeals opted not to grant interlocutory appeal for no stated reason, which is the typical response: they don't take leave. We then pushed it forward farther, and Drew Brodus from our office, who handles a lot of our appeals, asked the Michigan Supreme Court to review it, even though the Court of Appeals had declined to review it. And the ruling we got from the Supreme Court at that time was an order requiring the Court of Appeals to decide the case. So then we were in the Court of Appeals. Drew was successful in winning this issue with the Court of Appeals, and we won outright. Plaintiffs and intervening plaintiffs, a lot of them, in the assigned claims facility, obviously were not happy with that result, so they took it up to the Supreme Court again. Ultimately, Sentinel also retained Mary Masterson to argue and brief that the second time in the Supreme Court, and she had oral arguments in January. And then we just got the decision back. So we've seen quite an up and down process, and it's been a long fight, but ultimately with a good result, where now we have a decision from the Michigan Supreme Court that says, yes, indeed, there still is no innocent third party. Titan made that clear. Yes, indeed, there is no easily ascertainable rule. Titan made that clear. And yes, an insurance carrier can rescind a policy for fraud, and whether or not a quote-unquote innocent third party is involved, the insurance carrier is still entitled to that defense, that the insured has committed fraud, therefore the policy is void in initio or from its very beginning, as if it never existed. And so then this now says this quote-unquote blameless or innocent third party now may or may not be able to make a claim, which launches into a new test now that the Supreme Court in Bazzi has remanded to the trial court for determination of a balancing of the equities to determine of these equally innocent third parties, i.e. the carrier and this claimed innocent third party, who is more blameless in this equation. And that's what we're left with now going forward.
Right, so when the decision in Bazzi came down on July 18th, it kind of reiterated some basics that we know about this area of law. So, for example, an insurance company can rely on any common law defenses unless doing so is clearly prohibited by statute. But the court found that the No-Fault Act does not limit or prohibit the reliance on the common law defenses of fraud, and it doesn't limit an insurer's ability to rescind a policy based on fraud, even as to a third party, as Mark mentioned. So basically, an insurer can seek rescission of an auto insurance policy based on fraud, even for someone who's seeking statutorily mandated PIP benefits, because the No-Fault Act doesn't limit that ability to rescind the policy. But the caveat to all of that, and the big question that's going to come up in every case going forward dealing with Bazzi until potentially another case comes down, is the court indicated that rescission is not automatic with regard to a third party, even when the policy was procured by the insured through fraud. So the trial court is then tasked with balancing the equities, or determining who of these two quote-unquote innocent parties, the insurance company or the person who is making a claim and did not participate in the fraud, who is essentially more innocent. So who should the court favor? Should the policy remain in place as to that person, or should it actually be rescinded as to that person? The Michigan Supreme Court remanded that question back to the lower court in the Sentinel case so that that could be decided as to those two parties in that particular case. And I think that's what we're going to see, how this case will be applied going forward, at least until another decision comes down that may clear that up.
And on a practical note, I obviously, myself, as well as many lawyers here and elsewhere, have been defending a slew of claims just like this, where there's been fraud by the insured, and there's a claim by some other party claiming not to be involved in the fraud. And certainly we've won a lot of cases on this over the last several years since the Court of Appeals issued the first decision of Bazzi, before we just got this new one. But now I just got a briefing not an hour ago from a plaintiff's counsel now supplementing his response in another case I have, saying, hey, look, Bazzi came down, judge, you have to do this balancing test, and now we're going to get into these new issues, these new fights of who is more blameless. It's funny, who's the more innocent? And while the Bazzi court on the one hand says, yes, innocent third party rule, gone, easily ascertainable rule, gone, it almost seems in some ways that this is just arose by another name.
And that was kind of contemplated by the dissent. I want to touch on that briefly. Justice McCormick, joined by Justice Viviano, wrote that she disagreed that Titan abrogated the innocent third party rule. She found the present case distinguishable from Titan because PIP benefits are mandated by the No-Fault Act. The statute requires the insurer to provide PIP coverage in every policy unless coverage can be excluded under another part of the statute, MCL 500.3017, which is essentially the part of the statute that outlines allowable expenses and the reasonable and necessary requirement. But she said that public policy also dictates that all eligible PIP recipients get benefits, and that Sentinel is not, in that case, per her opinion, without remedy. It can pursue the assigned claims insurer, but it shouldn't be allowed to rescind the policy on the basis of fraud with regard to the third party who didn't commit the fraud. So basically, the bottom line is that an insurance policy procured by fraud can be declared void ab initio by an insurance company, but that rescission of that policy is not a right as to an innocent third party, but an equitable remedy granted in the discretion of the court. The trial court must then balance the equities to determine if rescission is a just and equitable remedy in each case, and basically decide which party should assume the loss when both parties are equally innocent.
And that's what we had to look forward to going forward. So I think that is going to conclude our webinar, and we encourage any questions. Obviously, reach out to Renee or myself. You see our emails on the screen, our direct dial phone numbers. You can reach us through the website as well. We look forward to hearing from you, and we're going to keep you posted as the inevitable and foreseeable continued decisions on this issue start coming down as to who is less blameless.
Should be interesting. Thank you for joining us, everybody.